Hey folks, I'm Mark Smith, host of the Four Boxes Diner. For those of you new to this channel, I want to introduce myself. I'm a constitutional attorney. I'm a member of the United States Supreme Court Bar. I'm a gun owner, and I'm proud to say that in 2021, a federal judge relied in part on my Second Amendment scholarship to rule that California's so-called assault weapon ban was unconstitutional under the Second Amendment. And if you support the Second Amendment's right to keep and bear arms like I do, please subscribe to this channel and help us spread the word to everyone on YouTube and beyond. Today, I have big news and not anything that you're expecting. And the big news is this, that in the context of these 365 pages of regulations that the Bureau of Alcohol, Tobacco, and Firearms and the administration have released as proposed rules dealing with so-called ghost guns, which, as you know, is a propaganda term for do-it-yourself guns, and also various regulations for harassing federal firearms licensees. Now, we're going to get to all these regulations down the road in future videos. We're going to talk about why I think most of these, if not all of these proposed regulations, are probably illegal. They're probably illegal under the Gun Control Act of 1968. They're probably illegal under the Administrative Procedural Act. They're probably unconstitutional under the Second Amendment. They're probably unconstitutional under the Commerce Clause. We're going to talk about all this stuff later, but not in this video. In this video, I want to tell you something that you will likely only hear on this channel. Okay? Here's what it is. The anti-gunners, in proposing these regulations, have made a terrible, terrible mistake for their own cause, which is a gift to the Second Amendment community. And I doubt their lawyers or they have even figured it out. Here's why. In these 355 or 360 pages of regulations, guess what they conceded? They conceded that the AR-15 type rifle is, quote, one of the most popular firearms in the United States. I repeat, they, the anti-gunners who propose these regulations, with all their lawyers and the ATF involved and all these so-called smart people involving guns, they've admitted that one of the most popular firearms in the United States is the AR-15 type rifle. Now, you might say to me, Mark, we all know that the AR-15 is a popular rifle, and so what? Who cares? Why is this a mistake? How did the anti-gunners screw things up for their side? The answer is this. By this concession, by this admission, by the regulations being proposed by the Department of Justice and the ATF, they have basically conceded that AR-15 bans in places like Massachusetts, California, New York, Maryland, and the like are unconstitutional under standing, unequivocal Supreme Court precedent. You see, today, based on the Heller decision and the Caetano case, the U.S. Supreme Court has made it very clear that the types of arms protected under the Second Amendment's right to keep and bear arms, right? How do they define arms? What's protected? Well, the arms that are protected, according to the Supreme Court, are those that are typically possessed by law-abiding citizens for lawful purposes. Again, typically possessed by law-abiding citizens for lawful purposes. Now, the anti-gun government agents that are proposing these regulations, right, they are admitting that the AR-15 type rifle is one of the most popular firearms in the United States. This admission demonstrates undeniably that as a matter of law, the AR-15 is a type of weapon that would be protected by the Second Amendment because it's typically possessed by law-abiding citizens for lawful purposes. I want you to compare this to the 2016 Supreme Court case in Caetano versus Massachusetts, which said that stun guns, I repeat, stun guns are protected arms under the Second Amendment, even though there's only maybe 100,000, maybe 200,000 stun guns in civilian hands in the United States. So it seems to me that with this admission by the administration that AR-15s is one of the most popular firearms in the United States, which we all know, but they've now admitted it in a public filing, in a huge public filing, this means that if the Supreme Court takes an AR-15 ban case out of, again, Maryland, New York, New Jersey, California, any of these states that have banned so-called assault weapons, then I can promise you that one of the things that will be hammered home by the Second Amendment lawyers will be this point that the anti-gun organization, the administration, if you will, proposing this 355 pages of regulations on the gun industry, they will pay a heavy price for this admission, because it basically means that we all agree that these are typically possessed firearms, these AR-15s, and therefore they're protected under the Second Amendment. And they can't be banned any more than handguns can be banned in Heller versus the District of Columbia. So again, I think this filing by the administration, despite the craziness that we're going to get to later on the stuff that's likely illegal, has at least a huge silver lining in favor of the Second Amendment community. And my guess is that the lawyers for the administration didn't even realize what a gift they were giving to the Second Amendment and to the gun rights community in upcoming cases before the Supreme Court dealing with the so-called assault weapon bans. Okay, well, I hope you learned something here today at the Four Boxes Diner. Stay tuned and don't forget to subscribe. We try to give you information you can't find anywhere else about the Second Amendment and gun rights in America. And again, we'll see you next time here at the Four Boxes Diner.
Orders up. Table 2A.